Let everybody get here. Wow, a lot of people. Good morning, everybody. I'll give everybody a few seconds to get situated before we get started. Okay. All right. Hey, my name's Andy Flink. I know some of you know me. For those of you who don't know me, nice to meet you. With me today on my panel are Lauren Smith and Pilar Prinz. I'll give you a little bit of information on both of my wonderful colleagues. Lauren is a graduate from Auburn University in 2008 with an English degree, has been practicing family law and mediation for many, many years. I met Lauren, I guess, when she was an associate attorney for a boutique law firm in Buckhead doing family law. She has 4 small children. I don't know how she does what she does, but she does it well. Lauren's also not only great at mediation, but is my go-to person when it comes to personal property arbitration. So for all of you out there that write in personal property arbitration into your agreements, instead of having to deal with stuff over 3 hours and 3 professionals in mediation, Lauren's your go-to person, okay? With me also is Pilar Prinz. I think many of you know Pilar from your time in family law litigation in Atlanta. Pilar was with many, I don't say many boutique law firms, but was one of I think one of the most respected family law attorneys that I had ever worked with. She got smart and moved to the beach. So she has the ability to continue doing what she's doing and still live at the beach. As a matter of fact, I think Pilar did that prior to COVID. So you didn't even know at the time, but you can do what you can do from there. Pilar is on our team as well as a mediator, just joined us recently and is a highly accomplished attorney and very, very good at ADR services. And both, without getting into a whole lot of promotion, both Lauren and Pilar are available to book mediations on the website of flinkadr.com, along with many other esteemed neutrals to help you guys solve your domestic and family law cases. Having said that, I want to kind of get started here today by giving you an overview of domestic mediation, and then at the same time, sort of delve into the different specific areas of what we look at when we're talking about family law mediation. But the first point that's really important to understand, and I'm sure many of you know this already, is that mediation in family law can be very different than mediation in civil and general practice. There are a lot of emotions in family law. There's a lot of management in family law. You have to balance that with what I would consider to be very careful reality testing, okay? Because people are at a high emotional level, and you have to be careful because they're scared, they're upset, they're angry, and you're always probably dealing with different personalities in each room. One of the topics that I like to, or one of the statements that I like to give everybody in family law mediation is I will tell clients typically that it perfectly makes sense that they come to mediation with what I call their emotional, rational, reasonable, fair, equitable position in what they think they should, that they think should be the rightful outcome of the case. But the court looks at it from a legal perspective. So it's important to help them understand that while you can be sympathetic to their position, at the same time, try to help them understand, along with their attorney, that the court sees it from a legal point of view. And I guess we always say that we can work with a scalpel in mediation, but the court's going to use a hatchet. So with that in mind, we only have an hour, so there's 5 different topics of areas that we want to deep dive into to give you a quick A to Z overview. And the first one we're going to start with is custody, which covers legal custody and physical custody. And with that in mind, I'm going to let Lauren take it from here.
All right, thank you. And we had discussed if anybody had any questions or anything, the Q&A section of your screen is open to collect any of those questions. And we'll probably address all of those. We're going to try to save some time at the end. It's a bad combination getting lawyers and mediators supposed to discuss everything within an hour. But we will do our best to save some time for questioning. So if you do want to go ahead and put those in there, we can review that as we go. But yes, I wanted to go ahead. And the main thing, if you have a domestic case and you're dealing with children, the biggest thing you're going to have to tackle most of the time is the custody piece. Often that's going to be the piece that has the most emotions tied to it. And it's going to be the piece that really needs the most thought. And it's the piece that I think is most appropriate for the mediation setting as opposed to the courtroom. Like Andy mentioned, in mediation, we can use a scalpel, while in you take it to a courtroom, the judge is more likely than not going to slap on a really standard plan that's not going to take into account any of the specific needs that a specific family may have. So, I really try at the beginning of domestic mediation to talk clients and parties through being able to think, let's really try to think, first of all, think long term, which is very hard to do when you have small children in a case. It's hard to think, maybe I would be okay with them being gone all summer when they're 14, when you have a 14-month-old. So trying to help people think through those different stages. But then again, even in mediation, we can think through those things and create a tiered system. So you might have a different, type of schedule, given the age of the children, and then say, the parties anticipate that after kindergarten, the summers might look different, or after sixth grade, the summers might look different, or different things like that. So that's sort of the overview I like to give people before we get started. I know everyone comes obviously from different backgrounds, and some of you practice domestic exclusively and all of the time. So I apologize if some of this is going to be a rehashing. But for those of you who primarily do your work in more general mediation, we wanted to make sure we were all on the same page of what we were talking about. So we wanted to start, and we've got the materials that were sent out. So I'm going to just share my screen here on the parenting plan portion of those materials that we sent. There are a lot of different, there's no magic ingredient on these. This is slightly edited. It's from a case that we had previously. So this is going to be pretty standard of what you're going to see. Some people just have different formats. So this is just a good thing to refer to when you're working through a case, just to kind of have a checklist of all the different things that you're going through. So we are going to start with just identifying the children that we are creating a parenting plan for. We just put the year of birth. We don't identify their exact birth date. And then a lot of this introductory language is just going to be statutory language that we're going to find in all parenting plans. The first big thing that I try to tackle first is making sure that everyone in the room understands the basic difference between physical custody and legal custody. Physical custody is when we are just dealing with where the children physically are. And then legal custody is where we're going to be dealing with who's making decisions for those children. So when we talk about physical custody, traditionally there's been a primary custodial parent and a non-custodial parent. And the non-custodial parent is going to have parenting time and visitation rights. More and more we are seeing 50-50, so true joint custody situations. Even within that, there is going to be some room to figure out exactly what that looks like. So I just wanted to kind of talk about a few of the types of physical custody plans that we look at most frequently. So when we're talking about that, if you have a primary custodial parent and a secondary custodial parent, what we're going to look at typically is going to be a weekend visitation. And so sometimes that, more traditionally, that was a Friday to Sunday situation. More often now we are seeing Friday from the pickup of school till Monday at the return of school. So that non-custodial parent actually gets that whole weekend, gets Friday night, Saturday night, Sunday night, returns the child to school on Monday morning. Whenever possible, I find, just as a practice pointer, that it is best to do exchanges at school or at childcare rather than creating a situation where those parents are going to have to interact for an exchange. So that's something to just sort of discuss with parties, as well as, is this a situation where it's going to be better to have a, a neutral site and at school pick up or drop off? Or is it a situation where it's not a big deal to have pick up or drop off be at either of the parents' homes? Then we also typically are going to have a midweek parenting time session for that non-custodial parent. Sometimes that's just going to be a dinner date. Sometimes it's going to be an overnight. We typically have that sometimes in the middle of the week. So most traditionally Wednesday, but sometimes you can do it on a Tuesday or Thursday. Really any day of the week is fine, but as something to talk with parties about of what makes sense. So for this example that we've provided, the parenting time during the midweek is from the end of school on Thursday until that Friday morning. And typically that's going to be on the weekend on the week when that custodial parent is not going to have their weekend parenting time, just so they get that touch point with the child on a weekly basis. And then this example we gave also has that weekend parenting time, like I discussed, that's becoming more and more seen. And it's going to be that Friday after school to that Monday pickup. Something that is really important to make sure that you do have in your schedule when you're discussing how you're going to handle all of these things is thinking about things like teacher work days and days that are going to be off. You can have some language that just says the parent who has the child on that weekend is going to exercise through that vacation day or that holiday day from school. Or we can say that the normal schedule is going to, resume whether or not there's school on that Monday or not. But that's just something to keep in mind of an issue that could come up if you're not used to seeing it on a regular basis. When we are talking about 50-50 custody, there's typically going to be two different ways of doing that. You're either going to have alternating weeks where you're going to do week on, week off. And then that exchange point can either be that Monday drop off at school, or sometimes it'll be Sunday night. Just sort of depends on the family. It really can be any time, but those seem to be the most natural shifts as we're shifting between week on, week off. A lot of times parents are more interested in doing that schedule with older children. And it seems to be that there's more of a want to have more frequent interactions if you have younger children. However, when you have younger children and you do a different type of 50-50 schedule, or children of any age, you do have to think about the fact that you're going to have many more transitions throughout the week. So those are kind of the two factors to think about when you're weighing whether or not it makes sense to do a week on, week off, or the other one, sometimes it's called a 2-2-5. And what that is going to mean is that one party will have the children every Monday and Tuesday night. The other party will have the children every Wednesday and Thursday night. And then you're going to alternate that long weekend, but Friday, Saturday, Sunday night. I personally find, and anybody else can jump in if you think differently, but I typically find that it's easier to count by night rather by days when you are trying to figure out how you're going to do it. Because it's just that overnight that seems to be easier to pin down when we are, trying to put together that schedule. There's 100 different ways in between to do a physical custody schedule, but those are kind of going to be your main ways of doing it. When we talk about legal custody, which is a little bit higher up in this plan, is when we are talking about important decisions that are made for the child. Day-to-day decisions, which you'll see here, is going to be made by whoever has the children in their custody at that time. But when we're talking about major decisions, we're talking about things like, are they going to have a specific surgery or medical procedure? What school are they going to go to? What activities are they going to be enrolled in? And what religion are they going to follow? So those are the 4 categories that the legislature has broken down to be legal custody categories: education, health, extracurricular, and religion. The 2 big ones that seem to most of the time, you can always have a situation that's going to be different, but the 2 big ones that people seem to spend the most time mediating or litigating over is going to be education and healthcare. And within all of those, just like anything else in mediation, you can get creative. You can say that, maybe we are going to break those big 4 categories down into even smaller categories. So for example, a lot of times people will have a specific feeling about, mental health versus physical health. And so maybe we can divide that category up a little bit more to say one parent is going to make mental health care final decisions about the child, while one parent is going to be in charge of more physical health care decisions. Even with schooling, we can say, this party's residence is going to be in a 50-50 arrangement. This party's residence is going to be used for school choice, but the other parent is going to actually make the, schooling decisions. Are they going to skip a grade? Are they going to go into an accelerated program? Those types of decisions. When we have, what most typically happens is you have a joint legal custody agreement. And so both parents have to be really involved in all of these major decisions in their child's life. There has to be true good faith conversation. Both parents are entitled to be involved in that decision-making process. But in the event that there is a disagreement, we assign a final decision maker, someone whose decision is going to be able to trump the other party's decision in the event of a disagreement after that good faith negotiation. And so that is when we designate a tiebreaker, and it's typically one of the parents in each category. So for example, if there is a disagreement about whether a child is going to have their tonsils out, they've gone back and forth 3 times, they've gotten 3 different opinions, they just can't decide, look at the parenting plan, say, mom has final decision making in medical and healthcare. And so whatever mom's position is on the tonsils is what's going to decide how we're going to move forward on that specific issue. The other ones that you can sort of also divide up, 9 times out of 10, we sort of divide up I divide up extracurricular activities slightly to either say both parents can pick one sport per child per season, or, in this situation where you have a non-custodial parent who has a weekly, night with the children, they can pick the activity for their night with the child. And then the other parent would be able to choose the other activities. And same with religion, unless religion is a very important topic for that particular family. A lot of times we say that the parents can exercise their religious practices with the children, but will not perform any religious rite with the children without agreement between both parties, and will respect the child's wishes. But you can also just do a straight, this party is going to make the religious decisions as well. That's a very high level on physical and legal custody, which is like 90% of what we're doing in a parenting plan, is just deciding where the children are going to be, how important decisions are going to be made. Once you get through that, the rest of the parenting plan is also rife with landmines that people can litigate about later, and certainly not something that we can cover in such a short period. But I do encourage everybody to look through this parenting plan. It'll give you some good ideas of some of those areas that are important to cover and think about. A few of the ones I wanted to touch in like the next 2 minutes, and then I'll pass it on, is that summer is usually going to have a very different plan than the school year. I'm going to stop sharing here because I don't really know that it's particularly helpful. But summer is going to be different than the school year most of the time. And so sometimes you can have big chunks of time in the summer. A lot of parents I've started to see over the last couple of years, have started alternating weeks in the summer, even if they don't do that in the school year, because they really are wanting to have more of a 50-50 relationship, but want to have more stability for the children during the school year. So that's something to think about. An important thing about summer is that if you are having parties make a decision about certain weeks of summer vacation they're going to take, you need to have, and our example shows this, that you need to have a process by which parents are going to put in their selected weeks each year, and whose decision is going to prevail on a given year. Another important provision to have in there is a conflicts provision. So if the regular schedule conflicts with the holiday schedule or the summer schedule, what takes precedence over the other? That's an important thing to go ahead and lay out so that everyone is on the same page and they can refer to the parenting plan rather than having to go to court or do a contempt filing in order to figure out an issue that could have been drafted more carefully as you go into the parenting plan itself. Again, if you look through this sample one, it has a lot of those provisions that we use a lot. There's lots of tools out there. You can use parent coordination to try to come up with different solutions for parents. Counseling can be put in there. You want to have communication provisions of how you're able to contact the child. And then some parents really like to have things like a right of first refusal, which practitioners most of the time can't stand because it's very difficult to navigate that usually. But basically what you're saying is that before a parent can put the child in a third party's care, they have to consult with the other party first. Something just to keep in mind with that is that you typically want to make sure you're very clear about when that right of first refusal would be triggered. So is it triggered overnight, 4 hours, 2 hours? Do grandparents count? Do step parents count? Those are the types of things to really to think about and to push people when they're going through that drafting process. So I know that was old hat for a lot of you guys, probably didn't make sense for a lot of other people, but we are happy to answer any specific questions. And if you have questions in a mediation session or you're drafting something, I know any of the three of us would be happy to help brainstorm some solutions or even help look at parenting plans as well, because a well-drafted parenting plan ideally keeps the family out of court. Because they're able just to refer to that document and find a clear answer rather than leaving something up to interpretation.
All right. Thank you, Lauren. Very, a lot of information, a little bit of time.
Yeah.
I do want to add a couple things to that. The first one is there are 3 reasons we need a parenting plan. One is because the court requires it. 2 is because if one party feels that the other has committed an egregious violation of the parenting plan and wants to file a contempt. Also if there is a dispute or if there's a material change in circumstance, if you will, and they have to go back to court to address those issues, or if there's a disagreement with regard to a provision. For example, I'm taking the kids to Florida for Thanksgiving this year, and the other person says, that's wonderful. I have Thanksgiving in all odd numbered years, so you ain't taking the kids to Florida. I'm taking the kids to Spain. Or that person can say, you know what, if you've already made plans, you take them this year, I'll take them next year. Bottom line being that we assume that the parents are not going to agree on anything. So to Lauren's point about writing a specific parenting plan to address issues, we're hopeful that parents can get along fine. There's an old adage that parenting plans, the best parenting plans are ones that are signed and put away and never looked at again. As practitioners, I can tell you that Pilar and Lauren and I have had experiences where I've drafted a 5-page parenting plan and they've never looked at it again. And I've drafted a 38-page parenting plan, and lo and behold, the next week, we forgot about something that we could have put in there that we should have put in there because they can't get along. So the objective obviously is, you know, if you guys get along, great. If you don't, there can be problems. We can't solve everything, but we try to do the best we can to address as many issues as possible. Pilar, do you have anything you wanted to add about parenting plans?
No, I think that's great. We could talk about it all day for sure. I think you've covered top level.
Yeah. Well, having said that, now we get to the money. Now we get to the dollars and cents. So we're going to move on to child support. And Pilar, I'll let you take it from here and talk about how child support works.
Great. All right. So I'm going to do this in a few minutes. Again, each of these topics we could have an entire lunch and learn on. But I want you to leave here, I think, with kind of 2 things to think about. Unlike a parenting plan, which, I mean, it's somewhat formulaic, right? Because there's a parenting plan, but there's so many nuances. Judges tend to think that child support, and it is formulaic, right? There's case law, there's law on it. There are very specific guidelines, and we're going to go through those in a second. But I think that the vast majority of time when you go into court, judges come in with the presumption of, I can just put the basic information into a worksheet and it's going to spit out a number and I don't need to do more than that. And I've had judges say that to me. That is true. However, when we're in mediation, this is the opportunity when you're the lawyer that you really get into it and argue it should be something different than the worksheet says. And as the mediator, it's really an opportunity for people to think outside of the box that is the child support guidelines. because while we know there are guidelines and we have to start there, you don't have to end there, and you're in mediation. And the point of this is to try to get people to agree. And really what works, just like every parenting plan is going to be different for every family, we all choose to spend money on our kids differently, and how we've chosen to raise our kids, and the lifestyle that we think they need, and the dollars attached to that are different. So what I'm going to do now is just go to the let's see, and Andy or Lauren, if you don't see this, tell me, okay? Hoping everybody can see this. And if anybody, I know, again, for family law practitioners, this is old hat. If you don't practice family law and you're new to domestic mediation, you may have done this in your training but not be as familiar. But the second thing that I was going to say is that the family lawyer should be coming to mediation with their own child support guidelines already done. That's something that I always want to see my lawyers do. But as a family law mediator, you need to know how to fill out this worksheet, because very often what each side comes in with is not what it's going to end up being. So if you're not already familiar with how to set up a child support worksheet, it's a good idea to practice it. The website is up here, but if anybody needs it, just put it in the comments and we can put a link there. So what you're going to do, it starts off with just the basic information. You fill in, usually you're in Superior Court. Let's pretend that we're in Cobb County. We'll just fill in names. You've got a plaintiff. You have a defendant. In this case, we don't have a non-parent custodian name. You would put in a civil action number. Don't think it's going to stop me from going forward without it. Let's say this is an initial action in a divorce, which means there is no initial child support order. If you were in the world of a modification that you're mediating, then what you're supposed to do here is put in the date of that original child support order, which usually is going to match the date of the final judgment from their divorce. You could put in comments for court like agreed to by the parties. You could say prepared by the plaintiff, prepared by defendant, really whatever you want to put there. And then here you're supposed to put in their last names. Their names again. I don't know why, but it makes you do it twice. And then you're supposed to say who's the non-custodial parent. Now, we know that it may be that they have 50-50, but for purposes of child support, the non-custodial parent is going to be the parent who has the lesser income. But let's just say in this case, we have a primary parent situation, that Joanna has primary custody and John has parenting time. Then you need to add a child to the worksheet. So you would click on that. You put in the child's name. Let's just say it's JT, and he was born in 2008, and he's going to be included. Again, there's lots of nuances we could spend all day, but I'm going to keep it pretty simple in this case. I'm the person who prepared it. And let's just say that the plaintiff is making it available. Okay, so it kind of skips down a little bit. I don't usually do this part until later, but one of the things that kind of comes outside of the basic child support number is going to be the way each parent is going to divide uninsured healthcare expenses. So not health insurance, because that's going to be assigned, but that's going to be co-pays, deductibles, out-of-pocket expenses, prescriptions, things like that. I usually do these at the end because, and again, we're in the world of mediation, so parties can agree to divide these however they choose to. What I think all of us find is that even when you have a situation where one parent has earned the vast majority of the income and they're going to be paying child support to the other, I've heard the term skin in the game, that they want, let's just pretend in this case, Joanna, the mom, is going to have final decision making over medical. And she's also been a stay-at-home mom and has no income or low income. John is probably going to say that she needs to pay something towards the uninsured health expenses to have skin in the game, so she doesn't run them up. I think most good parents do not run up uncovered health expenses for their kids, but certainly with things like therapy that might be $200 an hour. We have seen cases where that becomes a concern. So I'm going to skip that for now, but you would plug that in. So the next thing we do is we're going to go to, this is Schedule A, which is gross income. And you're going to see you've got Joanna and John at the top, and you fill in whatever's applicable. So let's just say everything is on a gross monthly basis. So they're going to be telling you what their annual or monthly income is, and you're going to fill it in. Let's just say that John makes $10,000 a month. He's a W-2 employee, and Joanna makes $2,000. She works part-time. Let's say John also receives a bonus that averages, sorry, I'm in the wrong place. Bonuses that averages $1,000 a month. Now you'll see there's all kinds of things down here. The law on what is included in income and child support is very broad. So really almost everything can be included. This is a place where lawyers can make arguments for their client. But again, let's just keep this fairly simple for purposes of today. So the next tab would be going to Schedule B, which is adjusted income. There are reasons that a parent's income might be adjusted for purposes of figuring out child support. So for example, self-employment income, you can put that in and you get a self-employment tax adjustment. In our case, we're not going to do that. We're just saying they're W-2'd. If somebody has what's called a pre-existing child support order, that they're ordered to pay child support for a prior child, that's something that you would fill in here. And each of these basically is like, you can add it here or you can edit or remove it. These are tabs that you can click on. Then you could also have a qualified child. We don't see this often, but it can certainly happen where there's a child that lives in the home that's considered qualified. So then we move on to Schedule C is health insurance and child care. And think about these as the must-haves, whereas Schedule E, the deviations, is kind of the may-haves. So you've got to fill out if someone is going to provide health insurance, unless they're on peach care, you've got to fill that out. And you've also, if there is childcare, which the law defines as necessary for work, this isn't a babysitter to go out on a Friday night, but you've got to fill those out if those are applicable. You can agree to do those off the worksheet, in which case you could not factor them into the child support number, and you could divide them by percentage in a settlement agreement. But it's really important if for some reason a court won't do that, but if you agree to do that in mediation, it's really important that goes in the settlement agreement, because if it doesn't, it's not going, there will be no money exchange. And someone's going to call very upset and say, I thought we agreed to divide our nanny 50-50. Well, if it's not on the worksheet or if it's not in a settlement agreement, it doesn't happen. So let's just pretend in this case that John keeps the health insurance and it is $500 a month. And let's say that there is no work-related childcare. So then the next place we would go is deviations. And again, this is where I'm saying that there is room for, I don't want to use the word argument, but certainly getting creative, looking at the family situation and thinking about what makes sense for this family and not just a number that the worksheet spits out. And I think that generally comes in the deviation section. So this is where you put in the may-haves. If you're in a situation where it's a very low income family, where simply, someone earns $3,000 a month and the child support number is just going to be prohibitive to them, then you may be looking at a low income deviation to reduce the child support amount. And that is all going to fill in here. And then whenever you have a deviation, the law requires that you explain it. So you go in here and you would type in whatever it is if you put that in. Conversely, you might have a high income deviation if you've got a really high earner. And very often for those of us that have practiced in the area of high income families have felt, and I know that the custodial parents have often felt that the number that the worksheet tells us is too low for their family. And they might be looking, sometimes they're looking for numbers that are 2 or 3 times what the guidelines might tell us. This is often the place to do it. You could put in a high income deviation. And then moving down here, parenting time deviation. So let's say you have a situation where you are really closer to 50-50. Let's say it's not week on, week off, but that John has extended weekends. He's got extra time in the summer, and he's really more like 40%. And he might be saying, it's not fair. I shouldn't be paying the same amount of child support as if I had my kids every other weekend. I'm incurring a lot of expenses for them directly. What you can do is you put in a positive or a negative number here, and that is going to shift John's child support obligation up or down. I'll tell you this, I have been doing this for a long time and I still get this wrong. I will put in the deviation, and sometimes I'll put it in intending for it to make the number go down and the number goes up. It's not a big deal. This is a spreadsheet, and if that happens, just go in and fix it. You know, you're going to go in and you're going to see what the number says, and if you say, whoa, that didn't do what it was supposed to do, just go and fix it so that it does. And then moving through the last couple ones, extraordinary education expenses for kids. This is often things like private school. It's broken down into tuition, room and board fees, and books. You put in I think it's a yearly number here. Yes, so this is one of the rare places where the worksheet is having us put in yearly instead of monthly. You're going to put in a yearly number. So let's just say that this child is in private school and Joanna pays, sorry, I have to add. You choose the child. We have one child, and let's just say that Joanna pays 5 on my thing. It's not working, so we'll just go with $12,000 a year. That would be great for Atlanta, right? How many private schools are 12,000? And it's paid by Joanna, and then you're going to hit save. And then the last couple here, you're going to have extraordinary medical. And then you're going to have, this is kind of the everything else for child rearing. So you can put in things like sports and extracurriculars and summer camps if they go above the guidelines. If you put in anything here that's a deviation, you're required to put in these findings of fact to explain why the presumptive amount would be unjust. So you would fill that in, and you really can write in anything that the parties agree to. So then, see if we've gotten enough to do this. We're going to do, no, see, it's going to actually make me write it in. So would the presumptive amount be unjust? Yes. Would it serve the best interest of the children? Yes. It will allow the child to stay in private school. And then would deviation seriously impair the ability of either parent to maintain minimally adequate housing, food and clothing? And you can say no. So hopefully that's going to be enough. We're going to save it. So we're going to call it Smith Worksheet. And then it gives us our results. What you're going to be looking at is this was the presumptive amount right here. Before we put in our deviations, it had John paying Joanna $1,193.25. Because Joanna pays the private school, that's why she got this deduction and John got a big bump up. And it has his final amount paying is $2,039. You can go in and you can make edits to this. You can play with it. If somebody says, oh, you know, let's add a special deviation for this or that, or take that out, I don't agree with private school. You can basically make the worksheet look however everybody agrees. So I'm going to stop sharing with that. And I know I could keep going on, but again, we don't have a lot of time. Also, the last thing I'll just say is this. We also included in the packet, I think there's an income deduction order if you need it, but the child support addendum that is required for the lawyers when they obtain the final judgment. Typically, as a mediator, I don't fill out the child support addendum. That's something that the lawyers do, but certainly be familiar with what it is. A lot of it is regurgitating what you've agreed to in the worksheet, needs to go into an addendum and get signed by the judge.
Great.
Andy
All
or
right.
Lauren, anything to add?
No, I think you covered it all. Thank you. We've got about 20 minutes left, and we have two other areas to cover. One is equitable division and one is spousal support. I'm going to jump in with equitable division and share my screen. For those of you that know me and have worked with me, you know that marital balance sheets are kind of my jam. So what I like to do is I like to create my own for a variety of reasons, specifically because I like to know kind of what we're dealing with and how much, you know, what the assets are worth, et cetera, et cetera. So this right here, and again, for those of you that have worked with me, this is what I see on my side, which you don't see. You will see this work product here. What I like to do is I like to identify all of the different items. I like to determine whether or not, you know, they're marital or they're separate property claims, et cetera. In this particular case, and I'll go through this again very quickly, this was the wife's first offer, and she wanted 87% of the estate that was valued at 1.958 million. She did give the credit for some separate property here, and she had some separate property here. You can imagine that that wasn't accepted. So then what I do is I take this worksheet and I'll cut and paste it and I'll make another tab. And this happened to be the husband's response. Okay. And what we're trying to do here, most of all, is get to this number right here, which is what are we talking about total that is subject to equitable division? If we can determine what that number is, then we can divide it. But if we're significantly off in terms of what we're dividing, it's going to be really hard to get any further. In this case, the first go around, we had 1,958,000 to divide. In the second go around, we had 1,689,000 to divide. Long story short, he came back at 51% in his column. So basically the difference to wife in this situation was the difference between 1,707,000 and $814,000. I mean, a gap we can all close very easily in mediation, right? Anyway, we get to the point where now she came back, went down in her offer. Okay, then he came back and went up in his offer. And again, I'm just trying to kind of get it to the point where you can kind of see how it goes back and forth. And by doing it this way visually, and you can send it out, by email if you're doing Zoom, you can show it on your laptop if you're doing it in person. It gets to show how far apart are we. Okay, we did 5 particular different offers back and forth, and we landed where it was a 55-45 split in wife's favor. But anyway, what I like to say is this is a great tool to use as a mediator. I know we're all different in terms of how we, I have a legal pad also. I like to use my computer because I can save the notes and save the information. It just helps me get better at what I do in terms of being able to utilize this. Regarding other tabs on here, I'll show you that I do take notes and I try to look at what the caucuses, what the notes from the caucuses are. I'll color code things here that are important that I need to know. Yellow might be a question I'm going to ask. Green may be where we agreed. And here's something kind of going back to what Pilar was talking about regarding child support, but it also incorporates alimony or spousal support as another factor. Something else that I like to do, and sometimes you don't have to announce this to your clients, but I like to look at kind of what are we talking about here in terms of income, right? So in this particular case, we have a spouse making $450 and another spouse making $50. So they have $500,000 worth of income coming into the house. There is a really neat website down here. I think we included it in our documents that we submitted. If not, feel free to email me and I'll send it to you. But what it does is it says, okay, if you live in Georgia and you make $450,000 a year, what is your net? Your net is $266,000, $265,000, $635,000. Same thing for if you earn $50,000 in Georgia. This right here gives everybody, we're starting from the same place. Nobody's paid an expense. Nobody's paid insurance. Nobody's paid all they paid is taxes. So this is what we know we have to work with. So in this particular case, this household brings in $25,441 in net income on a monthly basis. All right. This spouse brings in 87%. This spouse brings in 13%. If the child support is $3,500 and the spousal support is $6,000, all right, then what we look at now is what happens to the income. Well, in this case, it turns out that the incomes are equal. Okay. So you'll see sometimes that I know nobody's ever seen this happen. We want $10,000 worth of alimony. Okay. So sometimes people put that out there and say, well, this person makes, $37,000 a month. They can afford to pay that. But if you start to really start breaking down the numbers and looking at it visually and using some consistent calculations, you'll find that that really isn't the case. Okay. So this is a really good tool to use when you are looking at child support. And we're going to talk about alimony a little bit more in a moment. A couple of other things you want to maybe look at in this. And I know this is an equitable division, but it's my work product, and I want to help you guys get a little better at all the aspects of mediation. Is a party paying private school? Is a party paying for activities? If a party's paying $5,000 a month for private school, okay, now all of a sudden they're taking home $3,600, where from $22,000. The other thing I want to mention, the last thing I want to mention is the income consistent? In many cases, what will happen is parties will have a base salary, then they may get a bonus that might be quarterly, then they may get a bonus that might be annual. And a lot of times people will ramp up debt during the year and then they'll pay it all off when they get a bonus in February or March for the prior year. So sometimes ability to pay support is difficult because there may be months where they're just getting a base. Recently I had a case where a person made $1.2 million for the year, but has a $100,000 base salary. It's all based on commissions, and it all happens, during specific months of the year. So those are things that you have to keep in mind in terms of the income piece of it. Regarding the equitable division, again, real simple. What are the components? What are the values? What is marital? What is separate? And the last thing I want to say about equitable division is when you're dividing retirement accounts, when you're dividing investment accounts, those will be subject to gains and losses. So I always find that it's best to do it as a percentage. So if we're splitting one, if one spouse is getting 40% based on today's values, we say 40% subject to gains and losses. Sometimes I will hesitate and not ask and assume it, which probably is not a good idea. So I've tried to train myself to say, we are making this offer subject to gains and losses. Is that correct? Because you can get down to the drafting of the agreement and they say, whoa, wait a minute, we thought we were getting a sum certain. We didn't agree to that, and things can blow up. So keep that in mind when you're talking about equitable division. You can also do some tricky things with 401ks when it's transferred to an IRA via Quadro. We can spend another 2 hours on that. We don't have the time to do that today. But again, any questions regarding those things, equitable division, whatever, please feel free to reach out. Okay, we've got about 12 minutes left. The three of us decided that we were going to spend a roundtable talking about alimony because we know everything about alimony and we know nothing about alimony, right, at this point. It's based on one party's need. It's based upon the other party's ability to pay. I'm a sales commission. I had my best year ever, and they can't use that number as, a number for child support or spousal support. In the materials we sent out to you, that's a copy of, here's the question. What do you think the response would be in terms of what alimony would be ordered? And this was, I think, an end of court questionnaire that was put out a few years ago. I was asked to do it. I think some judges were asked to do it. And if you look at it, if 10 different people did it, there's probably 8 different answers. So since I don't litigate in court, all right, I'm going to turn it over to the two of you and tell me what your experiences are in terms of what you see people asking for in mediation in terms of spousal support, and what's really happening or what's the movement in spousal support, and what are judges doing these days?
Okay, I'll start. I think that alimony is definitely the most wild card of them. And it's the one that I think as a young lawyer, I was probably the most hesitant about because you don't know, right? And I would say, well, I don't know if somebody makes $300,000 a year, how much can they pay in alimony? Right? I don't know. And so that's where I think that running some of those cash flow analysis, like you were just showing, is huge. And I remember, I think Beth Garrett might have been the first person that did one for me. And I was like, this is brilliant because, it's very easy for parties to throw out numbers and say, I need $10,000 a month, or I can't afford to pay that. And the cash flow analysis really, if you see it in paper, it's like, wait a minute, you can afford this, or this is going to get you sort of here. So I think it's the hardest one in some ways, but for the mediator's perspective, I think two of the biggest things to me are showing somebody whether they can afford more than they think, because we hear that a lot, and getting past the emotion of it. There's a lot of emotion, of course, in child custody. There is a ton of emotion in alimony. A lot of people just don't want to pay it. You're going to hear, she can go back to work. She's underemployed, he's underemployed. The spending is outrageous. And so I think just because we're in the world of mediation, one of the biggest things to tackle, two of the biggest things to tackle are showing the realities of the finances, what can be afforded and what can't be afforded, and dealing with the emotion.
Do you give any kind of ballpark of like, this is a starting point? Like if someone asks you, I know you guys don't do quite as many. I do a lot of the pro se mediations. So their attorneys have probably already given them some ideas, but I didn't know if you kind of had like a rule of thumb of like, this is a total stab in the dark, but if you're thinking of a starting point, this might be in the realm. I didn't know, because I get that question a lot, and I was wondering what you guys say.
I've heard, I don't know if my percentage is accurate, but I want to say something like 17% of the income, and 1 year of alimony for every 3 to 4 years of marriage, right? Just as a starting.
Yeah, I've heard 10 to 20%, and then kind of a quarter to a half, which I think that when you can get someone to a half, that tends to be pretty lengthy alimony. You know, it's
Yeah.
usually landing more in the quarter to a third. Again, this is where lawyers get to be lawyers, right? And pull out all the facts that they should, you know, because you're trying to convince the other side in a mediation before you ever get to court. But I agree with Andy. That's kind of where I do my back of the napkin math. And then I put that into the cash flow analysis and into their life to see what does that look like. I don't just stop. I don't say, oh, it's 10 to 20%. But I do start there and then say, what does that actually look like? It was different back in the days when alimony was taxable and deductible.
Oh yeah.
Right. Because you kind of got to play with it, and now you don't get to do that anymore.
Right. Okay. So, go ahead, Lauren.
I was going to say the other question I get a lot is just sort of like, I think the idea of like the stepped up or stepped down aspect of spousal support, and that it terminates differently than other types of than other things we're doing. So I think that's something too. If people aren't super familiar, a lot of times you can structure things to say, you know, I think to the argument of she can go out and get a job. What I do as a mediator often is say, I mean, if she went, what's the most she's ever made in the last 10 years, 5 years? How long do you think it's reasonable to build that up? So a lot of times we can structure spousal support as saying, you know, we're going to front end it and do something for like a year to 18 months of a certain amount, and then maybe start to decrease that amount with the idea of maybe there's some more education that needs to be put in, or some time to be allowed to, you know, rejoin the workforce. But I think that helps the payor of spousal support to say, well, at least this is going in theory to something of this is, you know, creating an exit ramp for me, rather than just being shot with like a set, even if the total number ends up being the same. I think psychologically, a lot of times in negotiations, it can help to say, if we do it this way for 18 months and then maybe we taper it down, and they could get married in the time period and then your obligation might end. I think that sometimes helps get over that first part of, I don't want to pay her a dime kind of language.
Yeah, there's also, you know, we are all experiencing, it's sort of a overused term, but we're all seeing many more gray divorces, right? People that are older, in their 50s, 60s. So one of the other ways to measure is to determine, you know, does this get the lower wage earner or non-wage earner to Social Security? I'm assuming you all know this, but I'll put it back out there anyway. Social Security has a 10-year marriage rule where if parties are married for 10 years or more and they get divorced, then the spouse either can earn, when she's of Social Security age or he's of Social Security age, their amount of Social Security or half of their spouse's, whichever is greater, no effect on the other party. Okay.
Yeah.
Right.
And that's actually a question. I know we're going to save those to the end, but that might answer that question. Yeah. There was a question, is there a 10-year threshold for alimony? And I think that the answer to that, because I've heard that often, I think that might be confusing the Social Security rule with the 10 years being married. There is no actual threshold for alimony. I mean, of course, you're always going to look at the length of the marriage when you look at how long alimony might be. But unlike Florida, where I live and also practice, Florida is extremely formulaic in their alimony, and they do set it by lengths of marriage. Georgia doesn't do that.
Okay, so we've got about 5 minutes left. We've got 3 questions in the Q&A. What I want to do is answer those 3. And again, anybody out there, if you have other questions, please put them in the Q&A and we'll do our best to answer them in the short amount of time we have left. All right, so is there a good parenting plan computer program for purchase? I don't think so.
I don't know of one. Sometimes what I'll do though is you can go and a bunch of the Metro Atlanta courts will put up parenting plans for pro se filers to look at.
Forms.
And
Yeah,
they're just forms. And again, that's not going to give you all of the creativity, but if you use it as kind of a go-to of, oh yeah, we need to discuss transportation and pickup and things like that. So that's at least that plus ours, plus any other ones you can accumulate. Those are at least starting points, but I don't know of any software in it specifically.
And I'll
Yeah.
just add, because I mean, we're here to help everybody, be able to mediate, right? And if anyone feels like they need a provision about something, because the form is just a form, but you're like,
Right.
we need a really good provision about passports, you can always reach out to the three of us. I think collectively we have lots of provisions,
Yeah.
and we're happy to share if there's something in particular that you're looking for language.
Yeah, and we've learned a lot over the years in terms of how to handle, for example, spring break and making sure that there's no 3 weekends in a row and some creative ways to get around snags that we've experienced. So again, if you have any questions, please feel free to reach out. Over time, what you could find is that the more you do these, the more provisions you get, the more things you can go back and cut and paste over time to answer those questions. So that becomes the computer, at least in my practice. Okay. Can I share my spreadsheet? I'm happy, Beatrice, to share my spreadsheet. It's not ready to be shared because I'm not really sure. I gotta redact some things, but I'm gonna write down your name, and if you would be kind enough to email me at andy@andyflink.com as a reminder, I'll get it out to you. And if anybody else wants a copy of it, I'm happy to share it so you guys can use it in your mediations. Okay. There's a question on child support. Laura, I'll let you take that one.
Yes. Okay, I'll take that. Let's see. On child support in a 50-50 situation, you stated that on the worksheet, you list the lower income earning parent as the non-custodial. Can you explain the purpose? Okay, if I said that, I may have misspoken. You actually list the higher earning parent as the non-custodial. And the reason in a 50-50 situation. And again, you can do anything the parties agree to. Sometimes in a 50-50 situation, they might agree that there will be no direct child support flowing either way. But that, in my experience, tends to be when they also earn similar incomes. And so, the idea is we both earn money and we both have the kids half the time, so we're going to pay, on our own. But when you've got 50-50, but one parent earns a lot more, usually child support is going to flow still in a 50-50 from the higher earner to the lower earner. So you're listing the higher earner as the non-custodial because then the money's flowing to the custodial. I hope that makes sense, Logan. If it doesn't, feel free to email me. I can explain it more.
And that's typically when we're going to have some of those deviations too. So maybe you say if in a normal situation, that's supposed to be I think it's either 21 or 27% of time. I don't never get that exactly right, but it's something like that. So now we're saying you have 50-50. So maybe we're going to reduce that child support obligation from $2,000 to $1,500 because they're spending more time with the child and providing that the needs while they're spending that time. That's when some of those deviations can come in, and that's when you can kind of get creative.
Okay, so it looks like we are hitting the mark right on time. Again, thank you everybody for coming to our lunch and learn. I hope everybody enjoyed their lunch.
Yeah, no, we didn't get lunch.
Well, I know. They said they were going to serve it, but it turned out that they didn't. But what can I tell you? You guys, everybody have a safe weekend, holiday weekend coming up. And again, you can reach out to any one of the three of us. Going to flinkadr.com. All of our information, emails, everything you need is on that website. And again, we're here to help in any way we can to help in terms of getting to be better at family law mediations and helping people through the process as expeditiously as possible. Okay, and with that, y'all have a great rest of the day.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining. Have a great afternoon.
Thank you.